All right, continuing chapter 20, page 374, legal requirements for making a will. Now, in order to make a will here in New Jersey, you need to be of sound mind, legal age. Legal age is at least 18 years of age or older. Um, and the general rule is that if you have an entirely handwritten will, it's called a holographic will and does not require any signatures. Otherwise, any typed or printed wills, like if you use software to generate the will for you, it requires two witnesses. A beneficiary can serve as a witness to sign the will, and then you should get their signatures witnessed and notarized to ensure that the probate proceedings can go through a lot smoother. Okay. Now, for real property acquired by a married person before married deceased person before May 28, 1980, what happened on that specific date? New Jersey abolished the creation of any new dower and courtesy rights, if you recall. Okay. Uh, so um, for real property acquired by married deceased person before May 28, 1980, your spouse is entitled, they have an interest in all the property that you own. No matter what other provisions that you may be writing in the will, you can't write them out of the will. They have an interest in all of that property. But for anybody who was married after May 28, 1980, your spouse only has an interest in the primary marital residence. Everything else you could choose to leave to whoever you want. All right, so every state has its own laws of descent and distribution, and these laws come into play only when somebody dies without having made a will. Now, under the descent statutes, the primary heirs of the deceased are their spouse, civil partner, or domestic partner, and close blood relatives. When children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. In most states, illegitimate children, okay, let's stop right there. What's an illegitimate child? It's one where a child was born, but the parents were not married at the time. So in Game of Thrones mythology, you are the bastard child. You know, keep it up on the modern times, the lingo, the references, Game of Thrones, and all that. You know, I guess that was a little while back already. So let's see. So in most states, a little bit illegitimate children inherit from the mother, but they do not inherit from their father. That's messed up, especially since that's the actual blood father.
Wait,
You
can you say
inherit
that
from,
again?
yeah.
I'm sorry.
So
Can you
basically,
say that again?
if your child was born, but the parents were not married at the time the child was born, they're
Okay,
considered an illegitimate child, so they could inherit from their mother and claim to be a natural heir for the mother, but not from the
right.
father. Not unless the father proved, or not unless it's been proven that the father is in fact the father and he admitted parentage in some way, shape, or form, whether it's in writing or through a blood test or some way, shape, or form like that. So unless he's admitted parentage in writing or parentage has been established legally in some other way, um, then the child cannot inherit even from their own natural father. But if he does legally adopt his own natural blood child, that child would inherit as an adopted child would from the father, but not from his side of the family, his uncles and aunts and all that stuff. The father's uncles,
Mm,
you know, brothers, sisters, and all that. That child, even though they are a natural blood relative, they can't make claims of interest because even though if the parents were married, that child would have been considered a natural heir because
there.
they're in the bloodline, so to speak. Um, they uh, they still can't because the parents weren't married when he was born, or when she was born, when they were born. So intestate
Now,
will,
we're
yeah. Mhm.
I'm sorry, we're speaking before May, right? May 28th. This is all before May 28th of 1980?
Oh, no, no, no. This doesn't, this is, that's, so this is something totally different. We're just, that was the
Okay.
previous slide where we were talking about real property acquired by a deceased person before May 28th, 1980. That had to deal with the spouse inheriting from her, or his, so
Okay.
spouses inheriting from each other because you have
Mhm.
dower and courtesy rights. That has nothing to do with children. That only has to do with the spouse inheriting from their deceased spouse.
Gotcha. Thank you. Sorry.
Okay.
Now, this is talking about heirs, which would be like children inheriting from their parents. Okay. I mean, you're a natural heir of your parents, but if you were adopted, technically you were not born by them, you know, but you can't, but if you were adopted, your parents are your parents and you can inherit from them. You could claim to
Mhm.
be an heir because you were adopted by them, but you cannot claim to be an heir of their extended family from their parents or brothers or sisters because you're
Mhm.
not part of that bloodline. So you can't claim to be a natural heir and are entitled to something if they die.
Mm.
Now
Okay.
they could write you in their will and leave you stuff. There's nothing wrong with that. But you can't claim to be a natural heir of a family that you're not actually a part of the bloodline for, the true bloodline. Think of it like kings and queens back in the day, or those programs that you can maybe visualize. You can't claim to be the king, or you're not part of the bloodline. Think of it that way. It kind of works on the same type of premise. So uh, intestate real property. What's intestate? It means you died without a will.
Not a will.
Intestate real property is distributed according to these laws of descent and distribution, and it only happens when somebody dies without a will. Do these laws play a role that determines who gets your stuff after you die? If you're not a natural heir, I mean, if you're a natural heir, you could claim it, but who could get the stuff? Who's entitled to your stuff after you die? Who's going to get your stuff after you die? Even among the heirs, who could claim your stuff if you died without a will? Because we already spoke, and I believe none of you had a will yet, right? Hey, listen, I know it sucks to think of your mortality, but write something on a piece of paper, especially if you got
Mhm.
kids. All right. Look, to an individual who has died intestate is distributed according to the following order. The law and the estate discussed apply only when you die without a will, because otherwise things get distributed according to your wishes in your will. So let's see. Once again, that law of descent comes into effect only if you died without a will. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. Now, if there is a child or children who are also the children of that surviving spouse, the spouse or partner receives the first $50,000 of the estate plus one half the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first 50,000 plus half the estate. The rest goes to the parent or parents. If there's children who are not the children of the surviving spouse, the spouse or partner receives half the estate, the child or children the other half. When no spouse or partner survives, children become the sole natural heirs. And where there is neither a surviving spouse nor children or children's own heirs, the estate first goes to parents, and failing that, to brothers and sisters or their heirs. And then, in default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. But beyond that point, the entire estate goes to the state of New Jersey through the process known as escheat. Escheat is one of them terms you need to know. So, what is the process of escheat? Well, if you die with no heirs and no heirs can be located, the state treasurer sells the property at a public sale, giving notice by publicizing it in the newspaper in Trenton and in the county where the property is located. The proceeds for the sale are held in a fund for 1 year. And if no claims are made within that 1 year, the state keeps your money. They keep your stuff. The state gets it. So once again, go to unclaimedproperty.nj.gov to see if you have anything that may be due to you, and do it periodically. Do it every year. Every year you should go to that website. Missingmoney.com, you should also check that one out too. That's from other states that participated in that New Jersey does not. But you may be owed money from that too. If you or relatives are in other states, you may find a relative in another state and may be able to claim something as a natural heir, right? And that's the end of this chapter. Oh, did you need that one more time? Are you still writing, Yvonne? There you go.
Okay.
There you go. Keep that up there. Unclaimed property.nj.gov or missingmoney.com.
Okay.
Okay.
Okie doke.
You're welcome. And that concludes chapter 20. Let's do the key terms to review for chapter 20. Let's do the key terms to review for chapter 20 now. All right. So when a person named by the state to administer a descendant's will. Who's a person that you don't name in your will? So the state got to appoint somebody to handle handing out your stuff. A person named by the state to administer a descendant's will. There's a little kind of a hint there in there.
Administrator.
An administrator. There you go. One is A. Court proceeding to establish validity of a will. What's that court proceeding called? It determines what the assets of the estate are and who the heirs are. Make sure all your bills have been paid before your assets are distributed to any heirs.
See?
It's probate.
See?
Probate. 10 is B, probate. Title acquired by usage. So title's ownership. What do we call that ownership that's acquired by using a property? Title acquired by usage. When you've used someone's property and you could claim ownership of that property, when you've used it long enough.
Divide?
Adverse possession?
Adverse possession, 2 is C.
Okay.
When you've been in possession of someone else's property for a period of time as defined by law, you can claim ownership, but you have to go to court to do it. A person named in a will to administer a descendant's estate. But this is somebody who you named in the will.
Heir.
No. Who do you name in a will? If this is somebody who you name in your will to make sure, a trusted person that you name to in that will to make sure your wishes are carried out.
Executor. That's what I was.
Yeah, it's an executor or executrix, correct?
Right.
5 is D. Executor is the male, executrix is the female. So you may want to write next to executor / executrix. TRIX, executrix. That's a female. So 5 is D. Transfer of title without the grantor's consent. Without the grantor's consent. The grantor is the one who's giving the property, leaving the property, what have you. So what do we call transfer of title without that owner's permission?
Involuntary alienation.
Involuntary alienation, correct. 8 is E. Without having made a will.
Wait, where are we?
What do we call it when you didn't make a will?
Oh, I know. Intestate.
Intestate. 7 is F. One who makes a will. What do you call the person who makes a will? Who gives the will? Another little hint.
Testator?
Testator, correct. Testator. Let me see. 12 is G. Testator. Or testatrix if they're a female. Let's see. Document. So that was 12 was G. Document disposing of property after one's death. What's the document that dictates how you're going to get rid of your stuff and who you want to get your stuff? Come on, you shouldn't have to look at the answers. Think about it.
Okay, last will and testament.
Well, yeah, there you go. The last will and testament. 9 is H. See, sometimes you over focus and
Yeah.
it's, just stop. Think about it for a second. You got the answer in your head already. 9 is H. Having made a will.
Oh, testate.
Testate, correct. 11 is I. Acquiring a property by natural heirs. That whole section we read, it only
Oh.
applies. This law only
What
applies
number?
when you die without heirs
What
or
number
without
is
a will.
Um, um. Oh, your song, Devisee? Not the
Mm-mm.
Devisee.
No,
Oh,
no.
wait.
Acquiring of property by natural heirs.
Voluntary alienation.
Descent.
Descent.
Descent. 3 is J. Descent. Your descendants will inherit your stuff. Your descendants, right? So that's
Okay.
acquiring of property by natural heirs is by descent. Remember, when you die without a will, who's entitled to your stuff? Only your natural heirs. So the law of descent and distribution will determine who those natural heirs are who can make a claim against it. So 3 is J.
Okay.
One who receives real property through a will. What do you call a person who you named in a will to get stuff?
The Devisee?
A devisee, correct. 4 is
Oh.
K. One who can inherit those blood relatives. What do we refer to them as?
Hair.
An heir. 6 is L. And a transfer of title with the grantor's consent.
Voluntary.
Voluntary.
Voluntary alienation. 13 is M. And that concludes chapter 20.